very much. Right, John Rodway, whilst the invitation says health and safety, this is really at the worst end of health and safety, because this is about the ultimate thing that goes wrong in relation to people die and people go to prison. And so we're not really interested in the fact that people put a wedge under a fire door or have done things a little bit wrong. So John Rodway, I'm the Director of Corporate and Public Safety. I set the company up to assist small businesses who can't afford health and safety themselves. Health and safety officers tend to be expensive. There's a little bit of legislation that allows them to have a competent person, and I am legally competent. So the bits on the bottom here, the post-nominals, show that I'm a fellow of an International Institute of Risk. I'm a member of the Emergency Planning Society. I've got a diploma in safety management, and I appear on a National Register of Consultants, which indicates that I might know something about the subject that I'm talking about. But you get over 70 and you learn things as you go along. You learn every day. So, health and safety in changing times. The changing times, as we go through, I will indicate to you that things are changing in the health and safety world when it comes to when you've got it wrong. And you'll see a picture of emerging of how things have gone wrong in the past and what have been the consequences. And then the bad news in the middle is how it's changed in the changing times to what's likely to happen in the future. Then there's the good news of how to get it right, which is not very difficult. It means that you've got to fill in some forms and you've got to talk to people and communicate, which is what you should be good at in businesses. That's enough of me for the time being. How many of you are directors of a company? That's good. How many of you are managers of a company? Yeah. And how many of you are secretaries in a company? Right. Okay, that's good. At least we've got one each of you, because you'll see your jobs appear on here, on a screen, and you'll realise that life won't be as comfortable for you. You won't be able to hide, say I was only the manager or I was only the secretary, when it comes to a word called connivance. Okay, Grenfell, a year on, and lots of people are talking about it, lots of people are sitting and having meetings about it. But this little statement came out by a head of risk, that people now understand how things can go wrong if you don't keep on top of the small stuff. Keep on top of the small stuff, looking at a weather forecast before you send kids out to sea, making sure that the signalman who is repairing the signals knows what he's doing before the train crash, making sure that the doors are closed on the front of a cross-channel ferry before it sinks. Those are the small things that lead to mass casualties and create problems. So if you take care of the small stuff, you should then be able to take care of the big stuff, because the big stuff won't happen. People won't get killed. So we're going to look at three things. Corporate manslaughter, which is about the company ending up in court. Gross negligence manslaughter is about the individuals ending up in court. And the duties of directors. And there's a handout for you to guide you through duties of directors after you leave here. It'll give you some pointers of what you should be doing. Welcome. You haven't missed a thing, but you can sit down, no problem. Have a seat at the front. I can pick on you then.
You can.
Yeah, there's no problem. Are you a director of something?
Yeah, certainly you can.
What are you a director of?
Chartered surveying firm.
Oh, that's good. Yeah, I've got some chartered surveyors as customers. Yeah, useful people. Okay, corporate manslaughter. Nothing new about corporate manslaughter. The Lord Chancellor in 1844 worked out that if you are a corporation, if you are a company, you can get away with murder, because there's no legislation that can touch you, because there's no control in mind, there's just a load of shareholders and somebody in charge, and the law doesn't apply to you. And that's how it's been all the way through the 19th century and through most of the 20th century. Until 1993, when Peter Kite And Peter Kite was a simple businessman down in Dorset. He was running a sort of adventure camp for young people. And part of the adventure camp was that they got into canoes and they paddled around in Lyme Bay. The trouble was that Peter Kite didn't look at the weather forecast when these children went out in their canoes with their instructors. Peter Kite didn't give them any form of radio or any form of distress flares, and they couldn't communicate. So the children went out to their day's exciting kayaking in Lyme Bay. The weather turned bad, as the forecast said it would. The kayaks were sort of sent all over the place, and children died as a result of the weather turning, and they were drowned. And Peter Kite ended up in court. And the court looked at this and said, Peter Kite, you've got a company, you did wrong here, and you will go to prison because of your gross negligence in looking after these people. You didn't have a risk assessment, you didn't have a method statement, you didn't even bother to check the weather forecast to see if it was safe, so therefore you should go to prison. And that was the first successful prosecution of a corporation or a company. The interesting thing about successful prosecutions of companies for gross negligence manslaughter is it's always the very small company, the one that's only got sort of less than 50 employees. Big ones, Balfour Beatty and all that, they get fined millions, but they don't end up in prison because they've got a big legal machine behind them and a lot of paperwork, but they still get convicted. So some of you are old enough to remember 1987 when the Herald of Free Enterprise left Zoobrigger, as it always had done, with the doors open at the front. Anybody now would say, how stupid could somebody be to leave the front doors open on a boat when you're going out to sea? And the sea came into the boat and the boat overturned and 187 people died. And when it came to an inquest, the inquest said, right, that's unlawful killing. But we can't find out who was the controlling mind. Who allowed this to happen? Who said, close the doors? Who made sure the doors were closed? It transpires that the man who should close the doors, he's been working quite late. He's most probably had a little bit more to drink than normal, and he's fallen asleep. So instead of pressing the button to close the doors, he forgot, but there was nothing to tell the captain at the top in the bridge that the doors were open, because he just assumed that the man had done his job, because he's done his job every other trip. Then we have the Clapham Rail disaster in 1988, when 35 people died, no prosecution. The Clapham Rail disaster was caused because an engineer was tasked with rewiring a signal on the Clapham line. This is the 13th week that he's been working 7 days a week. So you can guess that he's a little bit tired by now, and he's rewired this signal wrong. So the train driver thinks it's safe to go, and the train behind thinks it's safe to go. And they go through, and all of a sudden the light turns red, he puts his brakes on, the next train hits him and pushes him into an oncoming train coming the other way. And 35 people die. But it was all down to the one man overworked who rewired something wrong. But nobody got prosecuted. Larkhill Gas, this is a Scottish gas, they get fined £15 million because 4 people have died. And the reason they get fined £15 million is they've got no paperwork at all to show where the gas main goes from the road to this block of flats. They've got no paperwork to show that it was ever examined, nothing to show it was ever tested, and the explosion is caused because it's a corroded pipe and it's leaked into this block of flats and it's blown them up and killed these people. But nobody gets prosecuted for the deaths. But at least Transco here get fined £15 million for health and safety breaches. Hatfield train disaster, 100 injured, and Balfour Beatty are fined £10 million. And this was caused because rail metal rail lines had some fatigue in them and they had some cracks in them, and the Hatfield Express comes through and it's leaning round on a bend and the rail collapses because of stress. Balfour Beatty knew about this. There was a company at the time called Railtrack, which is now Network Rail, but as a result of this case, Railtrack ceased to be. Network Rail took over because they didn't have a system for checking rails to see if they were damaged, or in their case they knew it was damaged, they didn't have a system for putting the rail in. In actual fact, the new rails were on the track further down ready to come along, but nobody had examined them. And 5 directors were put in front of the court charged with gross negligent manslaughter. And after an 8-month trial of these 5 directors, the judge said, I've had enough. Nobody's putting their hand up. We can't prove who did it. We can't prove who didn't do it. So therefore, they were discharged. And there was a £10 million fine. This led to changes in the legislation in 2007. And in came this wonderful new act, Corporate Manslaughter, Corporate Homicide Act. Now, this passed a lot of people by. That, you know, what's this all about? Why do we need corporate manslaughter? But that was the reason why we needed corporate manslaughter, because nobody was being held to account for what was going wrong. Serious management failures, gross breaches of duty of care. But it was about corporate bodies. It wasn't about you as individuals. Individuals are prosecuted under health and safety legislation. Corporations, businesses, are prosecuted under corporate manslaughter. So you will now start to see, or it's already been locally, a business in court for corporate manslaughter, and the business is convicted, so the directors can't go into business anymore, but also individual directors are also convicted and they go to prison along with their managers and others. And this is why I wanted to know how many managers, directors and secretaries there were. Because individuals prosecuted under Section 37 of the Health and Safety, it's a long, long section. You don't really want to read too much of it. But there's a little bit there about consenting and conniving. And you might think conniving is an old-fashioned word. But conniving is about, I knew it was wrong, but I didn't want to say anything because I didn't want to get a sack. Yeah, they asked me to send this, but I knew it would cause trouble, so I didn't. So it goes right the way down to lower levels of the organisation. I hope you can read this better than me, but the little bit here, consent or connivance attributable to any neglect on the part of any director, manager, secretary or similar officer. So anybody who has got their fingerprints on this trail of things that have gone wrong can expect to be in court. And a local business in Brighton, he went to court, corporate manslaughter and gross negligence, but his foreman also went to court. Now, the businessman wasn't even in the country when the accident happened. He believed everything was going okay. The foreman wasn't on site when it happened because he believed everything was going okay. But a subcontractor came along to do something, fell from a height and was killed. And so they were convicted and they got 9 months imprisonment each. And the company was fined £150,000. But this is one of the cases where it shows that directors, chief executives are now ending up in court, but also other people involved in the chain of communication end up in court. Other cases, Cotswold, this is a 2-man company. And they dig holes in the ground and test it for whatever geotechnical people test holes in the ground for. And they dug a fairly deep hole, but the trouble is the sides of the hole fell in and killed the man who was in the hole. So the other director of the company, he ended up, there was a guilty verdict, but he ends up with a fine of £385,000 and he's allowed to pay it back over 10 years. So the life of a person with his gross negligence in those days was worth £38,000 a year. Most probably a little bit less than they paid the man to dig the hole and do the geotechnical bit. Lion Steel, They get a young person to go up on a roof. The roof is fragile. They don't tell him it's fragile. They don't give him any training. He falls through the roof and dies. They get a fine of £480,000 and they're allowed to repay it between September 2012 and September 2015. So they're allowed 3 years to pay this £480,000 fine for the death of somebody. So obviously things weren't going quite right with this legislation because it didn't have any sentencing guidelines. 2010 saw a change here. Sentencing guidelines, the idea is to punish businesses but not to put them out of business. So the starting penalty will be £500,000. There's an unlimited maximum, but it's on a schedule now of 5% of turnover. Somebody of Nsure will know what your turnover is because there's somebody here who does the figures. So 5% of that, and if you get caught a second time, 10% of that. And if it's more than 500,000, that's what it'll be, 15 million, because you're a multi-million pound company, you know, that's what you can expect to be fined. So now that there are sentencing guidelines, and now that the HSE has changed the way it's worked, there is an increase in corporate manslaughter prosecutions. There are about 50 going through at the moment. What happened at a chicken farm today, where 2 people were poisoned by gas in a chicken shed, will most probably end up as corporate manslaughter. What happened yesterday, when a man, a coach driver, was walking past a block of flats and a window fell on him and killed him in London, that will most probably end up as corporate manslaughter because the window, whatever it was, 200 feet up in the air, wasn't secured. So somebody was responsible. So it's very easy for the HSE to mount a prosecution because they will work with the police, they will gather everything, and what they're looking for is risk assessments, method statements and training. And if those are missing, their case is proven because there's not much to prove in a case. Fairly simple. You need to make sure there was a duty of care, somebody was hurt, and there was some negligence. That's all they've got to do. The first 2 are provable. The person's there who got hurt or killed, and you had a duty of care to them. The last bit, a little bit difficult, but if there isn't any paperwork, it makes it easy for them. But gross negligence in itself is not new. It goes way back into the 1600s with people thrashing horses and taking carriages down the road and killing people because they're wanton and furious driving. But unlike manslaughter, it cannot be caused by omission. Gross negligence needs some omission. You should have done something, but you didn't do it. And if they can show that you didn't do it and you should have done it, well, then the case is most probably proven. And at that stage, it had an unlimited fine and you could go to prison for life because it was manslaughter. And the sentence for manslaughter, murder is mandatory life. Manslaughter is a recommended life, but the judge can give you, as we've found out with lots and lots of cases locally, can actually give you community service or probation or a suspended sentence because there's no minimum. Gross negligent manslaughter, as said before, duty of care, have you got one? Was it breached? And did it cause a death? And if negligence is the reason that there was a death, therefore the case is proven. It's criminal. So things started to change. Sherwood Rise was a nursing home, the Autumn Grange Care Home. And a dear old lady there who's 78 years of age, she is starved to death. Basically, she wasn't given any care, she wasn't given food, she was just an annoyance, but she was an income. And they could show that the directors here didn't look after this little old lady who paid for care. So they were taken to court and the 2 directors were jailed. One for 3 years because he was in charge of the whole thing and one for a year because he was in charge of the home. Linley Developments, this is a small company and they're digging a trench alongside a wall. And the men digging the trench said, this isn't safe. If we go down there, the wall could collapse on us. So the director said, well, I'm not really interested. I just want the hole dug. I just want to put a pipe through here and get on with it. Otherwise, I'll get somebody else to come along and dig the hole. So they dig the hole and the wall duly fell on top of them and the two of them died. One director got 6 months, suspended sentence, and the manager on the site got 6 months, suspended sentence. So it was obvious that things weren't working the way that the courts thought they would work because people are dying at work, and although we found out who's responsible, punishments aren't that bad. This case here, 2 men, this is a very posh block of flats in Belgravia, and the posh people who want this flat, they want a really expensive sofa to go into the flat, but the really expensive sofa is so big it can't go up the stairs, so they decide they're going to get ropes and they're going to pull it up from the outside. The sofa company said, yeah, that's no problem, we've got a lift, we can put it on a lift, it's like a giant forklift truck, and we can deliver it through the window. And it's £848 for you to do this. The developer says, oh, I'm not paying that sort of money, that's silly. I'll just get 2 blokes with ropes and they can pull it up and they can stand on the balcony and do it. But the balcony was built in Victorian times. It wasn't designed to have heavy sofas and 2 men stand on it. And the balcony collapsed and the 2 men were killed. So the director got 2 sets of 14 months imprisonment because that was gross negligence, and it was gross negligence for gain. He wanted to save £848 off of the bill of putting this sofa into a flat. Then we got one that's current now. Current now is 27 years old. 96 people died at Hillsborough, but a senior police officer has been charged with gross negligence manslaughter 96 times, 1 for everybody that's killed. That's still to come to trial, but he's been charged, he's appeared in court, he's pleaded not guilty, so that's waiting for a trial date. So this is retrospective. They will go back in history and find who was responsible for this, even if it takes a public inquiry. This is fairly recent, 2016, and most of you would have read about it, but there's a child on a bouncy castle. The husband and wife, who are directors, they didn't make sure that this bouncy castle was anchored to the ground securely, and they didn't check the weather forecast, and everybody knew that it was going to be a windy day. And the wind came along, picked up the bouncy castle with the child in it, deposited the child and the bouncy castle 300 metres away, and the child was dead. So they've appeared in court and they've received 3 years imprisonment for the gross negligence manslaughter, and they've received another year imprisonment for health and safety offences. So it's started to work. So new consultation, because they need to sort out what's going to happen with these people when they appear in court, because you can see from that people have got suspended sentences, some people have been fined, some people have got little sentences, some people have got no sentences. So 2017, some consultation. 2018, November next month, the factors that make gross negligence manslaughter more or less serious. Then there's 4 starting points. I won't go through the 4 starting points, but to give you an idea, very serious corporate manslaughter. If you have been negligent over a period of time, and we're talking weeks, possibly days, months, we're not talking about years, we're talking about fairly short, but over a period of time, and you were motivated by financial gain, you wanted to do this cheaply, it was a cash in hand job, you didn't check the credentials of the person who was doing it, you wanted to save money. You didn't check the machinery because you didn't want to employ a mechanic to check machinery. You can expect to get an imprisonment that starts at 12 years and goes up to 18 years imprisonment. If this is what the judge says, it's an A1 case, that is your penalty. You might get 10 years if you plead guilty. So it's now enshrined, or it will be next month, enshrined, this is what's going to happen to you if you've been charged and found guilty of this. At that stage, at that level, you will go to prison between 12 and 18 years. Much the same as if you'd stabbed somebody in the street or killed them otherwise. Lower levels, this is a company that's really good. They've got a good safety record, satisfactory standard of care, but they've been negligent in their conduct. The starting point now is 2 years. and the range is 2 to 4 years, and if you plead guilty, you can expect to get 1 year. There's nothing in this legislation and these sentencing guidelines to say anymore that you will get a fine, a suspended sentence, or a rap over the knuckles. If you've been convicted of gross negligence, manslaughter, you can guarantee you're going to go to prison. So this is a big change in the law, and these 50 cases that are coming up now are starting to feel the full force of the law. Why is it so important? A few years ago, 300 odd people a year died at work. Last year, it was down to 124. Really, really good. And this year, it's back up to 134. Really bad, because it's going back up. And who's dying? Strange when you look at the demographics of who's dying. The higher proportion now is people 50 to 65 years of age, because they know better. And so many of my clients, and I've got a lot of clients, you can't tell me about health and safety. I've been doing this for 50 years now, I haven't bloody died yet, is what I get. Because they built a company from scratch, Dad has built it, and now it's been handed over to sons, and they're carrying on. And the sons have realised, they've opened the health and safety drawer and there's nothing in there. And they know that they're now going to go to prison. And it's always Dad who says, well, you can't tell me anything about this. I've never died. I've never died falling off a ladder, putting in a window. I've never died going to sea and drowning. So it doesn't apply to me. Bad news is, it does apply to them. So that was all the bad news. The good news is contained in this little thing, and this is a fairly helpful thing that produced by the HSE, but just happens to have my logo on the top left-hand corner, top right-hand corner. Leading health and safety. And the Health and Safety Executive have produced this to help you as businessmen cope with everything that you're required to do for health and safety. And inside you will also find a little checklist that looks like this, okay, and it's got 30 odd points on it. And if there's anybody here can go through that and tick all of those and say, I've done all of that, well, then you don't need to listen to the rest of it, because you're perfect. Out of my 40 odd customers, I haven't found one yet who can fill in all 32 when I first approach them. Most of them can do it now. But you do need to start looking at what you have to do. Is there anybody at Nsure here who's brave enough to say we can cover all 32 points? It's a bit iffy. It's a bit iffy. And now the insurers. The thing about insurers, and there's a case to come up just recently where the insurers have gone to court and they've said to the judge, Judge, this company is so bad, we have refused to insure them. Now, there aren't too many insurers who will stand up in court and say we've refused, but this company was so bad that they refused to insure them, and it was a gross negligence manslaughter case. And I think in your world, it's going to become more and more prevalent that you're going to say to companies, well, we'll insure you, but can you show us your health and safety arrangements? Because you're insuring, like you're insuring a car, you say you've got to maintain it, it's got to be kept in good condition, and somebody's got to be licensed to drive it. And it's not much different with the health and safety of a company. You've got to have these things in place. If you've got more than 5 employees, it's got to be written down. If you've got less than 5 employees, you've still got to do it, but you don't have to write it down. Now, you try to explain to judge how you're going to unload your brain on all the risk assessments that you did in your head. He's most probably not going to take too kindly to it because he knows you've made it up. So, leading health and safety. What the health and safety is looking for, what the judge is looking for, what the police are looking for. Strong, active health and safety leadership. Leadership from the top. That people are involved right at the top of health and safety. You've got a policy and people know it. Okay? That it's visible, it's active from the board, and the board are engaged in it. The board member, have we got a board member here from Nsure? We've got a board member here. So the sort of thing that the board member from Nsure would do when he comes into a room like this would say, you shouldn't have a wedge in that door because it's a fire door. Take it away and get rid of the wedge. So that's leadership from the top. It's an inconvenience because the wedge has always been there and we've always been able to come in here. But the idea of the fire door is that when something catches fire in here, it doesn't go out there. So it's little things like that that board lead from the top. When did you last look at your health and safety policy? Anybody brave enough to say they looked at it last week? Well done, that's good. Anybody here hasn't got a health and safety policy? That's good. You need one. Because, you know, that's the sort of first failure, as it were. How many of you hold health and safety meetings where your employees are present? We're not doing too well. We got one. But this is a legal requirement. This is a consultation of employees' regulations that you must communicate with your staff. It doesn't have to be daily. It doesn't have to be weekly, monthly, quarterly. But you should have somebody from admin, somebody from transport, somebody from whatever to say, you know, let's have a little meeting. Are there any issues? And there might be issues. There might be stress issues. There might be DSE, displaced green equipment issues. There could be all manner of issues. But it should be on the agenda. When you have board meetings, on the board meeting, and you'll tell me it is, on your board meeting minutes, the second item after absences is health and safety matters. No. Anybody on their board meeting ever have health and safety matters? Well done. See, this man's brilliant. You know, he's almost 1 in a million. If we had 1 million people, he'd still be the only one. Okay. But people aren't taking it seriously. And these are the pitfalls for you when it comes to investigating you, because the health and safety are working off of a checklist, similar to the checklist of setting up this meeting today. Got one of these, got one of these, got one of these. No, I haven't got one of those, haven't got one of, have a summons. Because they know the case is proven. When did you last speak to your employees about health and safety? Have you ever asked them, have they been involved in a risk assessment? Or are you like other people, just write a risk assessment and put it in a file, we've got a risk assessment, but didn't talk to the employee who's digging the hole or mending the brakes? Sorry, what do you do for business?
Construction.
Construction. And a lot of my customers are in construction. So when did they get the health and safety briefing, the toolbox talk about cement and dermatitis and the damage to hands? When did they get, and this is a big thing with the health and safety executive at the moment, when did they get health surveillance and instruction about hand-arm vibration, where you get white finger syndrome? This is why Thurrock Council have just been fined £250,000. This is why I think it's Balfour Beatty are looking at a fine of several million, because they haven't done any health surveillance of their staff who are using vibrating tools. Vibrating tools, big thing. Not necessarily. It could be a strimmer, it could be a drill, it could be an impact drill, it could be a pneumatic drill, it could be a ride-on mower, it could be many things. And when did you last review your RAMs? RAMs are risk assessments and method statements. Every risk assessment should have a method statement. This is how we do things, this is how, these are the risks associated with digging a hole, and this is how we're going to dig it safely, and we're going to put shoring in it, and we're going to put barriers around it, and we're going to cover it over at night so trespassers don't fall in and die. You're responsible for trespassers, by the way. Anybody who comes onto your property, whether they're invited or not, trespassers, if you kill them, you're responsible because you should have left it safe. You're not allowed to put man traps in anymore. You're not allowed to cover up big holes with paper and make it look like concrete so they fall on the spikes. You're not allowed to do that anymore. It's illegal. Okay, practical steps. These are some of the practical steps you should be looking at. You've got a health and safety policy. Every year it's looked at, somebody signs it off and make sure that it's relevant to what your risks are at the moment. Regular risk assessments and method statements. Clearly identify who's responsible. So you've got the chief executive here or managing director. Who is responsible for implementing health and safety in the organisation? It's the next person down, because the managing director doesn't want to go to jail. So he's handing the go to jail monopoly card to the next person down the line. If you're handed that card, ask for a pay rise, because you are going to go to jail, along with the managing director, not a problem. Proper and adequate training. Proper and adequate training, what does it look like? Yes, you could spend a fortune sending people to expensive hotels in London to go on a training course, and food's provided and transport provided, and they've got a day out with the boys and girls. You can go online, and you can get good health and safety training online. at about £25 a head. They can do it in your time, they can do it in their time, and they get a certificate that is CPD approved, and you can show to anybody else you take this seriously. So all of your people have had asbestos awareness training, and you can prove it. Yeah. Your people, you haven't got a policy, so you most probably haven't given them any asbestos awareness training yet, right? But you can. By tomorrow, they could all have asbestos awareness training certificates. And it's another little thing out of the way, because every time you drill into an Arctic ceiling, you're exposing your staff to asbestos. You're responsible for that, and you didn't make sure that they're trained. Okay, board members appointed, regular updates to the board, and this is something that's growing. Non-executive directors coming onto your board. For 9 years, I was the non-executive director at Nsure and Port, responsible for health and safety, because maritime industry is a dangerous place. You can't breathe water. It's been proven time and time again. But big cranes lifting big things out of boats are also quite dangerous. So if you can't, or the job is too much at board level for your health and safety officer, look at acquiring a non-executive director to come on once a month, once every 3 months or whatever, to give you some advice, to look at the way that your firm operates and to give you advice. Monitoring, auditing, reporting, reviewing is all essential. So, what do you need to do? You need to find out your key areas of risk and how bodies such as the police, and the police will always be involved now, and the HSE expect these to be addressed. The reason the police are involved, they see it as a manslaughter conviction. So it helps their manslaughter figures. 50 deaths in Sussex last year that were manslaughter, 49 of them we solved because the HSE helped us. So it improves the police figures. They will want to see that senior management have been trained, that they've had some instruction about their duties and their responsibilities, that at the very least, every one of your directors has received one of these leading health and safety at work pamphlets for them to read and fill in and understand. You can say that at least you started it. Because if you're on a journey with safety management and health, they will be much more friendly to you. You weren't quite there, but at least you were on the way, rather than do nothing at all. Okay, train your senior management and the personnel. Make sure that they know what to do in the aftermath of an incident. So many times, it's very, very simple for the police and the health and safety executive to come in because nobody's done anything in that. You haven't even appeared on the television and apologised because we don't want, oh no, don't say anything. No comment, no comment, no comment. And you see it time and time again. People are killed at work. No comment. Well, of course you've got to comment. At least you're sorry that your employee of the last 27 years has died. So make sure people are trained in what to do and what to say. Understand what questions your organisation are going to be asked. Where are the current policies? Where's the reporting of incidents? Where's the recruitment and training? So reporting of incidents where nothing's happened is called near-miss reporting. Near-miss reporting, very, very important, because there's lots of people who go on university courses and build pyramids and everything else. And they can show that for every 300 near misses, there were 200 minor accidents, and for every 200 there were 100 major accidents, and for every 100 major accidents there were 20 serious, life-threatening, and at the top of the pyramid there's one person died. Because if you keep walking past that hole, eventually somebody's going to fall in it. If you keep opening fire doors and wedging them, if you keep piling up stuff at the fire exit so nobody can get out, eventually somebody is going to die. And the near-miss reporting should be the ability of all of you in this room to say to your manager, this is not right. I've got a neck ache and an arm ache from using DSE, display screen equipment. That's a near miss, because DSE in itself is a RIDDOR, which is quite serious, reportable incident. And if you put one of those in, the HSE come and visit you. Now they want to see is, when did you last have a DSE assessment where you sat at your desk and went through all of your display screen equipment and said it was compliant? I'll give you a clue, it should be once a year.
It was lovely last year.
Yeah, and everybody else is the same at Nsure. They all do it every year. A little online form that you fill in. Yeah, okay. But when somebody from Nsure has left and they've said, I've got repetitive strain injury, which is a RIDDOR reportable accident because you can no longer use your fingers because you're getting pain up here and this tendon is all swollen, it's RIDDOR reportable. It's also subject to compensation. They will come and visit you and they want to see your assessment, and what training. And they won't hesitate to give you a summons to say that you failed to look after the health and safety of your staff because you had nothing in place to let them tell you that they were injured or they were getting injured or things were going wrong. So it's not all about big burly builders falling off of construction sites. It goes right the way down to much lower levels in the organisation. And if you've given them training, make a record of the training. It's not very difficult. Susan taught Alice how to use this. That's a training record. Susan signs it, Alice signs it. That's a training record. It doesn't have to be a multi-page training record. It can be a simple card index. So the objectives: understand your health and safety role, recognise the importance of integrating health and safety in your business, take account of health and safety in your planning and decision making, know the consequence of failing to manage health and safety, understand the principles of health and safety management system. It's not difficult. It's very, very simple. It's how to run a business safely, but it's also how to stop you going to prison or you being fined tens of millions of pounds depending on the size of your company. No one ever comes to work to get injured or die, but you shouldn't have to rely on luck. And nobody should be saying, no, we can't do that because it's not safe. Find a way of doing it safely, much easier. Not always a good idea to put the electricity when the directors are having a drink in the pool because it will lead to problems. So, financial myths. That's me finished, and I'm happy to stand here for as long as you like for any questions or anything that you didn't understand from that little briefing about how to stay out of jail. You can't have the Monopoly card, by the way, of get out of jail free. It doesn't work. But the Monopoly card that says go to jail, don't go past go, don't collect £200, does work. Anybody have questions?
Yeah, I've got one. You talked a few times about directors being responsible for the health and safety of subcontractors.
Yeah.
Does that depend whether they're labour-owned subcontractors
No.
or bona fide subcontractors?
No. It applies to every subcontractor. And what you should have is a fairly simple document, because you use Charlie as a subcontractor. You need to do something about Charlie. Who is he? Where does he live? Has he got public liability insurance? Because if he hasn't, all of a sudden it's all falling to you. Has he ever been convicted of a health and safety offence? If he has, why are you employing him? What's his accident record? Has he killed people at work or injured people at work? Well, if he has, you now maybe don't want to have Charlie, you want to go and see Jack or whatever. Okay, and it's a simple document that shows that you took it seriously. And I produce a control of contractors policy for every one of my clients, because most of the deaths at work, especially in the construction industry, are subcontractors who turned up. Some of them have turned up cash in hand to do a job, dig a hole, move something, collect something from the site, and something goes wrong, and now this person is dead, or somebody else is dead as a result of this person, and you're in trouble. I won't name the company, but there's a company locally that moves waste, and they've got big lorries that you put the waste in the back, and it's got a big tipper and it tips it in. Okay, these lorries need to be serviced, and so one goes into the service bay, and it's got its body jacked up as high as it'll go, and somebody's working on it. And they finish working, and somebody says, all right, to drive it away? And he says, yeah, all right, drive it away. He drives it away, and he takes out the gable end of the building with this giant lorry. The gable end of the building is made of asbestos. He's made a big hole in it. So the company do the responsible thing, and they get an asbestos company to come along and do an assessment to remove the asbestos and replace it with non-asbestos. And that company subcontracts it to somebody else, who subcontracted it to somebody else. And when I visited, there's somebody else has got a transit truck, and he's got a ladder on the back of the transit truck that's leaning against the asbestos, and he's got a sledgehammer, and he's breaking off the asbestos to get it down. It's not going to cover the truck completely, because the cans of beer that he's been drinking are also in the truck. Okay. And who is it? No. Well, how did you get? Well, somebody asked me if I'd do a job for 100 quid. And I asked what the job was, and they said, knock that down. So I did it. So it's gone from a reputable company who did it right, all the way down the management chain without anybody challenging it, to somebody doing it cash in hand. And it turns out that somebody way back in the company actually knew about this, and somebody else got cash in hand. Well, not for long, because they didn't have a job. But that's how easy it is. Control of contractors, very important. You need to know who your contractors are, and you need to show that you've done what was reasonably practicable. You can't be perfect, but you need to show that you've been reasonably practicable, that you've done something. He might tell you lies, doesn't matter. You actually got the form where he signed off and says he will comply with all health and safety legislation. Yeah. Okay.
You said about the DSE assessment.
Yeah.
We actually moved it away from someone going around doing the questionnaire to actually incorporate it into our appraisal system.
Yep, good.
And we actually widened it to, because everyone was just focusing on the keyboards,
Yep.
we actually widened it to, is there anything in your work environment that is causing any issues for you? And then it's opened up. The actual managers have the thing. Because like I say, we did do exactly what we did. We had at the time 100 employees,
Yep.
send it out, and we get all sorts of funnies back. So then obviously the person going to investigate it goes there and goes, what are you playing at? Well, to me it is.
Yeah.
So you got a bit more, now we put it at the manager level, part of their appraisal.
Okay, and that's a good thing to do. But what it shouldn't end up is this form being filled in once a year and there's problems. If you've got good consultation with your
We do
employees,
that as it goes along.
it should be brought up maybe a month after,
Well,
2 months after.
We actually do it, as well as that, which is the formal, if you will, formal form.
Yeah.
They've all been trained, every employee, if you have any problem with your environment,
Good.
you speak to the people. Sometimes you have to say to some of the people, so they're not making a fuss, because despite saying to them you're not going to lose your job,
Yeah.
in the back of their brain they think they're going to lose their job.
Yeah. Yeah. Okay. Once you've got staff who know that you're taking things seriously and responding to their needs, you usually find that the majority of the staff are with you and will get things done and will understand it. It's a big ask to start with to say, right, 100 people fill in this form and we'll have a look at it. It's a little ask if it's, you know, if you've got a problem, tell your manager so that next time he comes to the health and safety meeting, he can bring up your problem. And that's much easier. Because one company that I work with, they've got a big board and it says, you told us the light was out in the toilet, we fixed the light. You told us that a gate was broken, we fixed the gate. So they can actually see where they near-miss reported things, that something's been done about it, and the rest of the organisation. And it's a simple thing to do. Somebody's just going to put it up on the notice board, or a lot of companies haven't even got a health and safety notice board, because if you had one, you'd have to put something on it. And one thing you should put on it is a law notice, health and safety law notice. Pretty thing, 4 columns, some photographs. You've all got one. You haven't. But that tells your employees what their legal rights are. You don't want to tell them that either. But those are the sorts of things that should be on your health and safety notice board. But this is the action you're taking. Health and safety policies, they can run into. The last person that I spoke to, who is now a customer, his health and safety policy was 86 pages long. Okay? And it says in his health and safety policy that every employee gets a copy of this. Can you imagine? Yeah. But, you know, he's got 47 employees. It's a big stack of paper. And the reality is that none of them have ever received it. But there's nothing wrong with having a proper health and safety policy that covers everything and putting it together in an A4 sheet to say this is who we are, we take it seriously, and this is what you can do about it if you're not happy, and this is how we review it, which is what the health and safety policy says. And you can stick that on your notice board so they can see who the director is, who's responsible for health and safety, and how it's being dealt with. And it can all be put on one side of A4. It's not difficult. Anything else? Oh, wait, this slide, didn't I? Oh, look, something from Nsure.
The changes that are coming in November,
Yeah.
is it purely corporate manslaughter or does it involve other injuries?
The answer is it will involve other injuries because they will take those sentencing guidelines now to say, right, this is what would happen in a case of death, okay? And this person has now got life-threatening injuries and he's almost dead. So you can expect much heavier sentences now than you would have done. So going back there where people were getting their fines on the never never, that's not going to happen anymore, okay? There will be substantial fines and there will be prison sentences. And if you put somebody into a wheelchair for the rest of their life because of your negligence, you in Nsure will be aware of the compensation side of it and the payments by the insurance companies, but there's also now a criminal penalty side to it. But it's heavy. Okay?
I've got one.
Yeah.
Just the use of technology, really. Are there any good apps for doing risk assessments?
Yeah,
and
there's
statements?
There's plenty. I don't know what your turnover in your business is, but one that I use is called Solution Host, which 20 odd of my companies have got. It writes their risk assessments, their method statements, does their cost assessments, does the training records, does toolbox talks, does accident reporting. It does everything all on one thing, and you can operate it from your iPad or your phone and just look at it and say, you know, if somebody says, oh, you've got a risk assessment for this, you bring it up, click it, and say, what's your email, and you can send it to them. That's one. That costs, it's very, very dear. It costs about £20 a week. But it covers all of your health and safety requirements. It even writes your health and safety policy for you. You've got to sign it and agree it, but it's all there. It does all the policies. There's another one called iAuditor. So, as in most things, it's a little I and it's a big A, whatever that is in secretary language. iAuditor is an Australian app. It's free. The basic thing is free. So you can build a little app, and I use it a lot. If I go and do an inspection in a company, I've got an app that's got all the questions I want answered on a walkthrough inspection. Is there a law poster? Are there fire extinguishers? Are they up to date? Is there first aid? Are the toilets clean? All these things. Question, safe, not safe, safe, not safe. If it's not safe, take a picture of it, point an arrow to it so that they know what bit is not safe. And I can email that to them while I'm on the site. I don't do that because if I'm charging them £300 to do this, they don't want to know that I've done it in 15 minutes. So, you know, I'm telling them that I'm sending it back to the office where somebody in the office is going to do this.
Yeah, note to self.
Yeah, note to self, you don't want to watch Emma Dale on Coronation Street tonight, so get on and fill that app in, you know, and then send it off the next morning, because then the customer has got a reply back within 24 hours and he's got a written report with the defects on it or the non-defects on it. The non-defects are good for insurance, the defects are bad. But once it's rectified, they become good. So that's a little app that's free. If you want the more expensive version of it, it's hellishly expensive. I've got the all singing, all dancing one that does, it communicates with my fellow director, and it's really, really, really expensive. It's £2.40 a week. You know, we don't know how to cope with these costs. But it's very useful. And it does fire risk assessments. I did a fire risk assessment in a town hall today, and it took me 3 hours. It'll take me about an hour to fill in the assessment. But they've got a fire risk assessment that is compliant with regulatory reform. So yeah, there are apps out there. Some are useless, some are good. But Solution Host is very, very good. By all means, contact the company, Solution Host. They're based in Sheffield, and they would give you a horrendous price, most probably £4,000 to £5,000 a year to operate this system. Because what they're saying is, we will become your competent person, we will become your legal advisor. And that's the sort of business that they're in, and they're a big business. Or they appoint resellers. I'm a licensed reseller for them. And it cost me just over £750 for a license. I don't need to make a lot of money. I've made my money in the past. You get to 74, and how much more money do you want to make? I just like putting a suit on, having a shower, do it the other way around. Having a shower, put a suit on, I might make a friend, I might make some money. I don't need to make a fortune. So I resell it at $960. It covers my diesel and my time to go demonstrate it and set it up for them. So there are lots and lots of things out there to help you. And once, you know, the company I was with yesterday, they put it in and it's doing everything for them. It's doing their training records, and it stores their training records. It's doing their asset register. So all of their assets, all of their plant and their equipment is all in this. Because it's on the cloud, it's available anywhere to them. So if they do catch fire and the insurer wants to know where's the list of assets, they can just press a button and it'll print it out without going around and trying to shake the soot and the dust off of something and think that's a drill. It doesn't. Sorry, who's next? Any more questions? Sorry.
In the time, that was all.
Yeah. No more questions? Thank you.
Good. Just before Richard comes in, so thank you very much, John. Found that interesting. I think most of us have got to just go away and think and probably twice in a few things, I think. So good food for thought there. Not insurance sale, but we are insurance brokers, so a little bit of insurance there. The one thing you do really need to make sure is that you've got directors and officers insurance, and I know looking around the room, a lot of people have via us. But please go and make sure you've got it, and make sure it's for a decent amount of money. It won't keep you out of prison, it won't pay the fine, but it might help you stay out of prison, or go to prison for a shorter period of time, or not pay so much for a fine. And also check to make sure that you've got something called entity cover. So directors and officers, that's for the director, or the manager, or the officer. So again, what John was saying, it's not just directors, it's people with that responsibility. Make sure you've got what's called D&O cover, make sure you've got entity. It's relatively inexpensive, by a decent amount. So that would be the insurance advice for you. Over to Richard.
Good evening.
Good news about my part is I'm not telling you why you are going to go to prison. I'm just going to tell you why you're going to be poor. Talking through some of the financial myths that I come across. Some of them are personal, most of them are fairly business related, but what I come across what I have come across, well, particularly in the past 5 years or so. As with most myths, some of them have an element of truth. You can see where the origin of the myth is, but things often get blown out of all proportion. Feel free to challenge me as I go through as to why I'm wrong about it being a myth, and I'll tell you why you're wrong. So let's crack on. So the first one, as I say, is one which for some people genuinely is true, but unfortunately for a lot of you, it actually won't be. And that is, my business is my pension. So when I talk to clients about why they need to save into a pension, lots of people tell me, I don't need to. Business owners tell me, I don't need to. My business is my pension. And then I sit down and start tearing apart why it might not be. It makes me popular. This is how I win clients and influence people. So what you've got to consider is, what is your business worth without you? Because for a lot of people, they are the business. And that's actually a big compliment to you. You are generating all this money. You are the business. You might have some employees, but if you are the business's lead salesperson and the manager of it, what is it going to cost to replace you? And you might well find that wipes out all of the profits that you've got. You might find that you're the one with the IP, you're the one who comes up with the ideas. Again, if you're not there doing it, what is it going to cost to go and hire that? And ultimately, someone who's that good, why won't they go and do it themselves? So you've got to be really careful. Now, I say, that's great, treat that as a bonus and plough money aside as well, because also we all know, I'm sure some of you in here have had businesses that go wrong. You know, there's a stat, isn't there, that for entrepreneurs have typically had 2 failed businesses before the one that makes them money. You might not get to the 3rd one. It could go wrong later in life. So just be aware that having other assets, and rather than just depending entirely on your depending entirely on your business, is actually very, very high risk. Treat it as a bonus. The one which is almost, but for some people it will work. You know, I have a fair few clients over the years who have successfully sold their business and done other things, and that's how they've retired. The one which never comes true is my home is my pension. I've only had, and I should explain, this is a family business, me and my father and one other advisor, Lorna, who's here. Between us, we typically deal with about a retirement a month. We were tossing up the other day that between us, we think we've dealt with about 300 retirements in the past 15 or so years. Across that, racking our brains, we can only think of a single client who has successfully downsized and freed up enough money to produce a decent income. Because when you think about it, the costs of moving are very expensive. People like where they live. And you know what we have done plenty of times with people is people have moved in retirement and spent more money. Really, really common. So relying on your property as your pension is, like I say, it virtually never happens. According to my stats, which is bang on 0.3% of the time, it actually works. We do increasingly do equity release for people, so that is where they stay in their home and effectively take out a lifetime mortgage, which has roll-up interest and such like, but can free up sizable chunks of capital. But actually, the idea of downsizing to provide your pension income doesn't work. And the other thing with homes in particular is we find as well that money is psychologically spent 3 times over, because you've decided it's going to fund your retirement, your kids have decided it's going to pay off their mortgage, and the local authority have decided they're having it for care home fees. So, you know, only one of you is actually going to get it. So it's really high risk to consider your home as your pension. One of the reasons people don't do pensions is because it dies with them. Nowadays, structured right, that is virtually never true. In fact, structured right, that is never true. There are certain company pensions and such like which might have a spouse's pension only on a really strict definition of what constitutes a spouse, which means it might stop with you. But company pensions almost always include, will have some level of spouse's pension, and personal pensions are always inheritable. So structured right, your pension will outlive you. If you die before 75, it can pass down the line, inheritance tax free. After 75, it passes down the line with the recipient having to pay income tax to access the money, so being in a no worse situation than you would have been. So the dying is not a reason to not save into a pension. Hand in hand with that is that you shouldn't transfer out of gold-plated final salary schemes. So it's been in the press quite a lot lately that people who worked for companies many years ago have got what they thought were small pensions with them that are really big pensions. And people have always referred to these schemes as gold-plated. And they are gold-plated. The benefits you get from them can be fantastic. However, because of that, companies are very often willing to pay you a very large sum of money to give them up. It would be a bit like, to use the gold-plated analogy, you've got you should never sell a gold-plated watch. Well, it depends what the other person's willing to buy it off you for. In half the cases, yeah, what you're offered isn't a good deal, but some of the figures we've seen are absolutely phenomenal. The most extreme one was a client who had a pension which didn't even know what it was going to be worth, but that was going to pay out £38,000 a year. She was well chuffed with that. But the employer that she was leaving paid her £2.2 million to give it up. Now, that was a pension which, if she died, would have gone to her husband at half rate, so he'd have got £19,000 a year. Instead, if she dies, he gets £2.2 million. This was a couple who were worried about how they were going to pay off their £120,000 interest-only mortgage, and were worried about how they could send their second child to university, are suddenly multi-millionaires just by exploring this route. Not all values are that generous, but it's certainly worth asking the question, and you shouldn't dismiss it because you should never do it. Always look at the other side of the equation. Right, most of you in here are business people. Most of you, from hands up earlier, employ people, and some of you have seen me talk before about auto-enrolment. Now, auto-enrolment we've been talking about since about 2010. Back then, it was all about who it was going to affect when and what you were going to have to do. Now it is in place. So this is having to enrol employees into pensions. And we've been through the different staging dates. Everyone who employs someone now needs to enrol someone in their pension. In a pension scheme that qualifies. So that's job done, a lot of people think. I'm afraid it's actually not. For starters, we've got the contribution rates creeping up. So in April next year, the employer contribution goes from 3% to 5%. From 2020, they're talking about widening the scope of who it applies to. So at the moment, you have to be 21 years old before you are automatically enrolled. People under that can choose to enrol. They're talking about doing with the age 21 assessment and making it all employees. And then the other thing, which is still very much in the consultation phase, but is doing away with this minimum earnings level so that everyone has to have a contribution regardless of earnings. So this is a moving feast. It's something that you need to keep on top of. And I've come across, well, certainly last year, a fairly what I thought was a substantial outsourcing payroll provider didn't realise that the employer contributions had to go up. So as with the health and safety side, it's your responsibility as directors to make sure this is in place. We have started to see the first prosecutions for breaching auto-enrolment requirements. Everyone here based in Sussex? Anyone not? Got some bad news for you. The pensions regulator is based in Brighton. And they're prosecuting typically through Brighton Magistrates Court. There seems to be a disproportionate amount of business in the local area being pursued because possibly it's easy. So we're seeing companies fined for breaches. We're seeing directors individually fined for breaches. You have got to go some to do that. So the most severe case that's been reported was an employment agency where the directors, or a director, had set up email addresses for all of their employees, which went to his email account. He was sending that email address the auto enrolment notification, and then opting out on behalf of the employees from there. That's quite extreme. I can't remember the size of the fine now, but the two directors got whacking great fines for that and banned from being company directors and all sorts. But there are some more minor breaches that people are starting to get caught up in. So you have to re-enroll people every 3 years. The first batch of companies that had to do that happened last year. You have to notify employees of their rights to join the scheme, even if they're not going to be auto-enrolled in it. There are lots of ongoing obligations that you really need to be on top of. And then the other thing is your scheme actually appropriate for the employees that you've got? Now, this is still in the infancy in this country, but because auto-enrolment's not that old, but you are responsible for picking the scheme that your employees enrol into. You also have an ongoing duty to ensure it remains appropriate for them. There has not yet been a case in the UK where employees have even thought of suing and pursuing the employer for putting an appropriate scheme in place. However, it is a booming market in the US and Australia who have had schemes like this for about 15 years. So it's only a matter of time before it comes. So you do need to be ensuring that the provider you're using is suitable for your workforce and the default investment in choice is suitable for them. Some of you might be sitting there thinking, I don't employ anyone, I don't need to worry about it. And in that case, you're correct, provided you are the only director of the company. As soon as you've got a second director on an employment contract, then yes, you do need to do it. And it is something to just lock away and remember for when you do employ people. Because I've had 3 phone calls this year from people who didn't previously employ people who do, saying they've been working here, in one case 4 months now, despite the fact you have to enrol people at 3 months. And I think I need a scheme, what do I do? Interesting, all of those people told me that I know I've got to do it, but the employee's not interested, he's going to opt out straight away. None of them did. And we're seeing that picture across the auto-enrolment landscape, that the expected dropout rates when it came in, or when the white papers and the consultation was done 10 years ago, they're expecting dropout rates in the region of 40%. It's actually only been 15%. So people actually want to be in these schemes, and the inertia of auto-enrolment is working. Another one I hear sometimes, I hear a lot, cash is king. Now this to me is a misquote. It's a bit like the love of money, that money is the source of all evil. That's not the correct quote, it's the love of money is the source of all evil, but people choose to drop something off to make it a bit more catchy. Cash flow is king, I agree with that. And having cash reserves in your business is sensible. However, hoarding too much cash can cause you serious long-term detriment in terms of investment returns. I know I would say that, wouldn't I? But secondly, in terms of capital gains tax and inheritance tax. Could talk on both of those for an hour in their own right. I'm not going to, you'll be pleased to know. Inheritance tax, in simple terms, if you're passing on a business that's unquoted, you don't pay inheritance tax on it, provided it hasn't got excessive cash in it. And secondly, for capital gains tax, again, you can have something called entrepreneur's relief, which means you can sell your business and only pay 10% tax rather than the usual rate of 20%. Again, if there's excessive cash in it, you can lose that. In addition, the things to consider, the more common problem I come across, is people trying to extract cash at the end of their career. So people who have diligently saved over the years, kept it inside the business, and in some cases have hundreds of thousands of pounds in cash in their business, want to wind up the company, want to stop working, saying, how do I get it out? Well, we're limited on what we can do in pension contributions to the tune of about 160 grand if structured right. And if you take the rest out as a dividend, you're going to pay the top rates of tax. You're going to be an additional rate taxpayer paying 37.5% tax in addition to the 19% corporation tax. So getting cash out of your business as you go can be a very sensible, is a very sensible move. I bet no one in here has a lasting power of attorney. Anyone willing to say what they do? The health and safety consultant. These are essential for everyone. They are as important, if not more important than wills. Actually, I bet half of you haven't got wills either, but that's a whole separate issue. These allow someone to manage your finances if you lose mental capacity. If you don't have one of these, for one, people think it won't happen to them, and you are probably correct. 3 out of 4 of us retain mental capacity till the end. I don't know, so in this room we've got 20 people, 5 of you won't, and I don't know which 5 of you that is. In fact, looking around, I've kind of got an idea, but I'm not going to point you out. This is an insurance policy against not being able to manage your own affairs. Without it, you need to go to the Court of Protection. You don't, you've lost capacity. Your family needs to go to the Court of Protection, apply to be a deputy. It's an very expensive and lengthy process. It's a very intrusive process, whereas with a lasting power of attorney, that person you've nominated to be your attorney just acts for you and stands in your shoes, effectively without accountability to anyone other than the ongoing fiduciary duty that anyone in that situation has. A deputy has to account regularly to the Court of Protection of why they're doing and why. The most extreme example I've seen of that was husband and wife. Husband lost capacity, in fact both were in an accident. Wife recovered fine. When the wife wanted to manage her affairs, his affairs, she couldn't. It turned out that most of the money was in a bank account in his name. Went to the bank, they froze the account. She went to the Court of Protection. Eventually, they made her a deputy, but she had to account everything to them. She had to, when they wanted to, when the roof needed repairing, she had to get 3 quotes for the roof and explain which one she was going to use and why. Who wants to live like that? The other thing that's really key for business people is whilst an attorney can't act for you as a director, they can't stand in your shoes in that sense, they do act for you as a shareholder. And there are certain things that shareholders need to do, aren't they? Pass certain resolutions, pass a resolution to approve the accounts and such like, which if you are a one-man or one-woman company and you haven't got anyone to do that, you could end up in the situation where the piece of paper that needs to be signed sent to company's house can't be, which means your company gets struck off and the state get the assets. Quite an extreme scenario, but that's, as business people, why you should all have powers of attorney, because your directors as well could, your attorney as well as the shareholder could appoint a director to run the company. Court of Protection is never going to let them do that. So absolutely, for all business people, really, really key. It's something you can do on yourself or get an estate planning professional to do it for you. Financial advice used to be free. At the moment, for the past 4 or 5 years, had quite a few what we call orphaned clients come through the door. So where their advisor has pulled out the market. Financial advisors aren't often very good at announcing their retirement. They just kind of disappear and you phone up to speak to them and there's a disconnected phone line or whatever. Nothing dodgy's gone on, they've just retired and such like. And they come to me and say, right, how's this work? And I explain about the fees that we charge. And they say, my old advice never used to charge that. Financial advice used to be free. It never was. There was always commission paid. You were always paying it through more expensive product charges. In effect, products are now cheaper, that you would buy, the investments you buy are cheaper, but you pay for the advice separately. It was never free. If your advisor told you it was free, they were lying to you, quite frankly. Finally, I don't need a financial advisor. If you got all of those right, then you don't. Otherwise, you probably do. Thank you very much. Any questions? No, I will hand back to Phil. Thank you for your time.
Well, very, very briefly then, thank you all for coming. Thank you again for our two speakers, John and Richard. Hopefully you found that useful. Please fill out the feedback forms, I did remember that. Can you also give back any lanyards and name badges? I suppose the table at the back, don't mind doing that. There is still some food left and some drinks, so feel free to hang around if you wish.